Good morning, everyone. Welcome to our Fair Housing program this morning. My name is Monica Staff. I'm the General Counsel of the Rhode Island Association of Realtors and statewide MLS, and I will be your moderator today. We've got an action-packed program, so let me go over a couple of logistical issues, and then we'll get going. So first of all, I would just like to remind everyone that we're on a webinar format. So if you do have any questions for our presenters, you'll see a Q&A button probably at the bottom of your screen. It might be the top, depending on what kind of advice you have. So what you want to do is type a question into the Q&A. I did have some people ask me before the program, we're a little bit nervous since we have federal regulators as our guests, if they want to ask a question. So if you are a little bit shy, you can type in your question anonymously. You just can rename yourself as anonymous or someone else's name if you want to. But anyway, they don't bite. They're going to do a great job for us today. Also, if you see a question someone else has asked and you have that same question, there's an upvote option. So you will see that when you're in the Q&A. And so it's kind of a thumbs up, and that will get that question. If it has a lot of votes, that will push it to the top when we're ready for the question and answer format. So what I'd first like to do is, or secondly, I guess would like to do, is to introduce you to the chair of our Diversity and Inclusion Committee, Agata Del Borgo. She will give us some welcoming remarks and introduce our two presenters from HUD. Go ahead, Agata, thank you.
Good morning, and thank you for joining us. In this challenging time of historically low housing inventory, it is especially important we provide professional and equitable service, treatment, and opportunity to our clients, colleagues, and consumers. We are pleased to welcome two special guests from the United States Department of Housing and Urban Development, which enforces federal fair housing laws. Our first presenter is Susan Forward, Regional Director of Federal Housing and Equal Opportunity Office and past Director of Equal Opportunity, Greater Boston Board of Realtors. Our second presenter is Attorney Jeffrey Sussman, who is the Center Director for the Office of Federal Housing and Equal Opportunity. Thank you so much. Take it away, Susan.
Thank you very much. And I'm pleased to be here today with you at the Rhode Island Association of Realtors. I do want to say that while I am director of the Office of Fair Housing and Equal Opportunity at HUD in Boston and have been with HUD for 32 years, before being with HUD and just before, I worked for the Boston Board, the Boston Real Estate Association and Greater Boston Real Estate Association, which is one of the largest in New England. And in that role, I was director of equal opportunity, and I trained many realtors over the course of 3 years, thousands in fact. And the response from the board was exactly what we're seeing now. Discrimination was tested for in and around Boston by the Commission Against Discrimination, and quickly the real estate board recognized that their members were vulnerable. These were issues that maybe we needed to educate on. So our goal at HUD, as it was with the real estate board when I was there, is not only to look at cases of discrimination and make findings, but it also is to train the members of real estate associations and those engaged in practices of real estate to have them understand some of the very nuanced issues that Jeffrey Sussman will be going over in his presentation. There are mistakes made, there are things said, and there are very many nuances to the fair housing laws. We can't expect people to know it all. I understand that that is your discipline, your profession, and you are tested into your profession. So you have had courses on fair housing. We're giving you a HUD perspective on how we look at cases. So I think that will be very helpful to you. Feel free to ask those questions that you may not want to. Understand that you are our client too. We take complaints of discrimination. We get complaints filed by members of the general public, but we often get questions from real estate brokers. And we are happy to answer those questions. It is a very nuanced law. I understand that back in the early days of fair housing, I think early 90s, there were a lot of questions about advertising guidance, for example. Whether you could advertise master bedroom or a walk-in closet, We were surprised to hear those questions from the real estate community, but they are in fact legitimate questions. There were questions about whether you could put the Easter bunny in an advertisement around Easter time. As silly as maybe that sounds, for back then, those were issues that we negotiated and issued advertising guidance afterward on exactly those issues of what to do. Mostly we're looking for equity, as was said by your chair of the diversity committee. We're looking to ensure that people who are in the housing market are afforded equal opportunity. And cases are brought when they feel they are not afforded equal opportunity. Sometimes we often don't find discrimination when someone brings a complaint. But I think it should be all our goals to ensure that no one feels excluded in our society. I know you think that too, and we appreciate that. So I want you to relax into this presentation and enjoy what we have to say. Jeff does a fantastic job and has put together a great presentation that I'm looking forward to hearing as well. So, and feel free to ask your questions in chat or however else, because we want to hear them. We want to understand what the issues are and how we can make this better and clearer for you. So thank you for that. And I look forward to the presentation and your questions.
Thank you so much, Susan. Before we move on to Jeffrey, just want to remind some of you who may have joined us a couple of minutes late, if you do have questions while Jeffrey is speaking, you'll find the Q&A button at the bottom of your screen or top of your screen, depending on what device you have. And that is going to be the best way to ask your questions. So we'll go through those once Jeffrey's finished. Okay, and again, thanks so much for joining us. I put it in the chat in the, oh no, I didn't. You haven't seen it. I also wanted to just welcome, I know we have some other guests from HUD in the audience today, so we want to thank you all for joining us as well. Okay, Jeffrey, I am done gabbing, so we're off to you. Thank you, and thank you, Susan.
Hello, hope everyone is doing well, and thanks for being here today. And happy Fair Housing Month. Each April we celebrate the anniversary of the signing of the Fair Housing Act, the law that I am going to be talking about a lot today. And so we are celebrating that right now, and we do a lot of outreach during that month like this. So I am excited about that, and we're gonna get started. There we go. My presentation works, and I hope you can all see it. So I think the first place to start is really an understanding of what our office does. And the best way to understand what our office does is through the mission that we serve every day, which is at the Office of Fair Housing, our work is to eliminate housing discrimination, promote economic opportunity, and achieve diverse, inclusive communities by leading the nation in the enforcement, administration, development, and public understanding of federal fair housing policies and laws. So it's a big mission, and there's lots of work to do. And just to give you a sense of the size of our mission and how much work there is to do, in the last few years, and these are the most recent data from our annual reports, so 2020's report has not come out yet, but you can see we've received in settlements of cases and cases that go to court over $18 million in 2018 in relief and close to $17 million in 2019. And I'm sure when the 2020 numbers come out as well, the number is in that ballpark, if not higher. Likewise, our offices nationwide and the agencies we work with, the state and local agencies that we call FAP agencies, those are under the Fair Housing Assistance Program, and that would include in the state of Rhode Island, the Rhode Island Commission, Rhode Island Commission on Human Rights and Opportunities, their investigations. But nationwide, we average just under 8,000 investigations per year. So there's a lot of work out there, and those investigations are bulk, not all, but a bulk of what it is that we do.
For 3 years.
So what I want to do right now is just give you a sense of some of what's going on in the world regarding fair housing. And I think the place to start is right here.
For 3 years, reporters at the Long Island, New York newspaper Newsday put hidden cameras and microphones on investigators and sent them out to pose as home buyers. They wanted to see if real estate agents treated white, Black, Hispanic, and Asian buyers differently. The differences were stark. Newsday's investigation showed that agents steered minorities away from mostly white neighborhoods and showed them fewer listings. Black homebuyers were most likely to be discriminated against. Here's camera footage, basically audio footage, in which real estate agents are steering white customers away from certain neighborhoods.
On the school bus, see the moms that are hanging out on the corners.
But you don't want to go there. It's a mixed neighborhood. It's been in United Nations.
I can't say anything, but I encourage you. I want you to go there at 10 o'clock at night. Go to that 7-Eleven. I have to say it without saying it. You know, you have the knowledge of the areas.
Yes.
You know. I don't want to use the word steer, but I try to use another word.
Listen,
I educate in the area.
So Keith Herbert, we heard the word steering. It's the idea that real estate agents would steer some people towards certain neighborhoods, some people away from certain neighborhoods. I assume you found that a lot as well.
Right. That's the most common sin, if you will, that a real estate agent can make in that they use whatever methods to quote unquote steer, and the term is racial steering, where they would send the minority buyer to a neighborhood that was more diverse and the white buyer to a neighborhood that was less diverse. As part of our testing, like I said, we collected over 5,700 listings. Those listings had addresses. We were able to plot those addresses in census tracts, which would give us the information about whether a minority tester was sent to a more diverse neighborhood and the white tester to a more white neighborhood. That occurred roughly a quarter of the time that we send out testers.
Keith, we have with us one of the testers that you recruited. Her name is Johnny Mae Alston. She's a retired civil servant for state government. She was paired with a white woman of similar age named Cindy Perry. Johnny Mae Alston, thanks for joining us and welcome to On Point.
Thank you, Sasha.
Johnny Mae, when you went out and spoke with the real estate agents before you later learned the results of how they had also interacted with white home buyers, did you feel you were being treated equally?
I surely did. I thought they went above and beyond.
Why did you think that? What made you feel confident in the service you were getting?
Because they were so friendly, and they were like giving me a 101 and home buying and telling me what I needed to look for as far as, you know, my paperwork and things like that. And they were very friendly, smiling. I mean, I would have never suspected a thing.
Later, you were shown, I believe, transcripts of how the realtors had dealt with your white counterpart. What did you then find differences?
Oh, yes. I was really in a state of shock just about because, you know, I never realized that she was actually getting treated different. I thought we were the same, but once I found out, I was a little bit shocked about that, you know, and it wasn't a good feeling.
What were the differences? What was the thing that shocked you most?
That when I went to one real estate office, they told me they couldn't take me out because I didn't have my pre-qualifications. But the other tester, she didn't have pre-qualifications either. But they took her out, and it was like nothing. You know, they were like happy, and they was like enjoying, you know, talking with her and treating her to a ride in the car. So,
Did you feel like you were being directed toward or away from certain neighborhoods in retrospect?
not really, not when I first went in there, but after I found out about her, then it came to me that, yeah, I mean, why would she send me there and not send me here?
So what you just heard was some comments about a story and some a big testing project that was done on Long Island. It involved testing, and you heard how that testing is. And often testing is used as a way to find out whether discrimination is occurring. And it goes without saying, the best way to avoid being the subject of one of these investigations, or not to be the subject, but to be found to be discriminating, is to just treat people equally. And you might look at this study in Long Island, which got a lot of press, and say, well, that's Long Island. I can take my chances elsewhere. This is probably not going on elsewhere. That's just not true. these practices are not limited to Long Island. Fair housing groups, often funded by our Fair Housing Initiatives program, are out doing testing and finding discrimination throughout New England and the nation. Here's one recent example from our region, New England. So here's a paper from July 1st this year. And right there in the bottom right is a story that says strong bias against Black renters seen. Boston study also shows voucher holders shut out. So this study came out and it also involved testing. You send a pair of folks to apply for housing, one of a protected class, one not of a protected class, and you compare treatment. They did this, what's called a matched pair test, at a bunch of properties, and they looked at whether testers were able to make appointments to see properties, how many units housing providers told testers about or showed them, whether housing providers offered financial incentives, whether housing providers made positive or negative comments about housing units, and whether housing providers offered testers an application. Specifically, this was done by the Housing Discrimination Testing Project at Suffolk with the help of the Boston Foundation. And they recruited testers and assigned 200 individual testers to contact housing providers of 50 different apartments in the greater Boston area that were randomly selected from common rental property listing sites from August 2018 through July 2019. And this made a lot of news. And here's what they found. 71% of their tests showed evidence of discrimination based on race. You might have noticed in the last week, the state of Rhode Island added source of income to its state law, which is equivalent to the Fair Housing Act. While federal law does not have that protection, it should be noted that this study did look at source of income and found that voucher holders were discriminated against even more, somewhere in the tune of the upper 80s, low 90%. So discrimination is occurring, and it is occurring everywhere, and it is widely occurring. So here's some quotes that I think are worth looking at from another article about this study. They pointed out that researchers said real estate brokers play a significant role in contributing to discrimination in the rental housing market. More than 180 of the 200 participants had contact exclusively with real estate brokers, agents, and someone from a property management company. Only a few had direct contact with landlords. An overwhelming majority of the testers dealt with a broker at some point in the process of inquiring about the property. So here's a quote. "The real estate professionals are part of the problem," said Berman, the Suffolk law professor, "and they should be part of the solution. People are required to take vouchers, and they cannot treat someone different because they have a voucher or because of their race or any other protected class." And what we want to do by doing outreach, which is part of our mission and having these presentations, is to teach you about the law so that you understand what it is that you can do and what it is you can't do, and exactly what is discrimination under the Fair Housing Act. So let's go through that a little bit. Under the Fair Housing Act, you can't discriminate based on race or color or religion. And just to be a little clear on what religion is, the prohibition covers instances of overt discrimination against members of a particular religion, as well as less direct actions, such as zoning ordinances designed to limit the use of private homes as places of worship. It's not the most common form of discrimination we see in our office, but it does occur. National origin is another protected class, and that is far more common, the basis of a complaint that we would see in our office. Is a really big one, accounting for about half of all the cases that we see. So the Fair Housing Act defines a person with a disability to mean those individuals with mental or physical impairments that substantially limit one or more major life activities. The term major life activities may include seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. And the Fair Housing Act also protects persons who have a record of such an impairment or are just regarded as having such an impairment. So understanding what it is to be disabled and what those protections are is really important, because this is by far the most common form of discrimination that we see in our office. Familial status is another protected class. Here we're dealing with families with children under 18. So in addition to prohibiting an outright denial of housing to families with children, the Act also prevents housing providers from imposing any special requirements or conditions on tenants with custody of children. For example, landlords may not locate families with children in a single portion of a complex, place unreasonable restrictions on the total number of persons who may reside in a dwelling, or limit their access to recreational services provided to other tenants. So this one is also fairly common. We often see it in a lead paint context, and I think we'll get to some of that in our question and answer section later. And another is sex. So the Fair Housing makes it unlawful to discriminate in housing on the basis of sex. Recent years, we've looked at this and focused a lot on sexual harassment in housing. So that's a big area that we've been looking at and doing a lot of work in. But there's been a lot of movement as far as what sex discrimination means. You might have seen this headline from the Washington Post just a couple months ago. On February 11th, our office issued a memorandum stating that HUD interprets the Fair Housing Act to bar discrimination on the basis of sexual orientation and gender identity, and directing HUD offices and recipients of HUD funds to enforce the act accordingly. The memorandum begins the implementation of a policy set forth in President Biden's Executive Order 13988 on preventing and combating discrimination on the basis of gender identity or sexual orientation. So this decision was based on the department's legal conclusion that the Fair Housing Act sex discrimination provisions are comparable in text and purpose to those in Title VII of the Civil Rights Act, which bars sex discrimination in the workplace. There's a Supreme Court case, Bostock v. Clayton County, that held that workplace prohibitions on sex discrimination include discrimination because of sexual orientation and gender identity. HUD now has determined that the Fair Housing Act's prohibition on sex discrimination in housing includes sexual orientation and gender identity. However, you here in Rhode Island already have these as their own coverages under the state's law that is equivalent to our Fair Housing Act. So there's many ways that folks discriminate, and there's lots of protections in the Fair Housing Act. So let's go through them. This one's fairly straightforward. If you are involved with failing to rent on the basis of any of those reasons that I stated, that's discrimination under the Act. If you refuse to sell a property based on a protected status, that too is discrimination under the Act. Quite often, discrimination takes the form of treating people different in the terms and conditions of their rental, saying, well, if you're going to have children here, we're going to make you pay a higher security deposit, or we're going to make your security deposit higher because of your race and setting lower security deposits for individuals of different races. There's any number of terms and conditions that can exist in a transaction. But when people are treated differently because of a protected class, it's illegal and a violation of the Fair Housing Act. You also have to be careful when advertising to make sure that those statements don't say anything which could be deemed as discriminatory. Now, there's lots of guidance out there as to what you can and can't say, and I've given presentations with a big focus on that topic. But for today's purpose, just know that it's important that you don't use language which could indicate a preference for certain groups. That could be not having a preference against families, or it could be more explicit toward race or some of the other protected classes, or be designed in a way to exclude individuals with disabilities. You have to be careful about the language you use, because language matters and statements are covered too. So while advertising is one thing, if you tell someone something, that is a statement, and that statement, if discriminatory, can be the basis of a complaint with our office and could be violative of the Fair Housing Act. So probably the most common issue we see in our office involves reasonable accommodations. And a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. or fulfill their program obligations. So we see these all the time, and they can take any number of issues. If you have a disability and you need something that just a policy change, like, can I have someone, give me a phone call to tell me something as opposed to put it in writing, or vice versa. It's just any sort of change that's needed. But then we also have coverages for reasonable modifications under the law. And these are a little different. This involves a structural change made to a premise. So whereas reasonable accommodations are about just changing a policy or procedure to accommodate someone's disability, modifications are things that generally are more expensive and require actual changes. So if you need a washer dryer installation, you might need to put in new pipes to make that work. That would be a modification. But if the pipes are already there and the machines are there and you just need permission to use the machine, then that would be an accommodation. So there's often this conversation as to whether it's an accommodation or modification. And that distinction is important because an accommodation, if there's expenses associated with it, that's going to be borne by the property owner. Whereas modifications under the Fair Housing Act, they're the responsibility of the complainant if there's costs. However, permission to make those changes would be borne by the property owners. So that's important. If there's federal funding, however, then modifications must be paid for by the property owner. And that's subject to Section 504 and if it's a public entity under the ADA. So it's important to know that, but in most instances, the modification costs are borne by the individual who needs the accommodation, or the modification. Another form of discrimination involves design and construction. And this includes the failure to design and construct covered multifamily dwellings for first occupancy in a manner that public and common use portions of such dwelling are readily available to and usable by individuals with disabilities. The doors designed to allow passageway into and within the building are wide enough to allow individuals with disabilities and in using a wheelchair to get through. The dwellings also have to have adaptive design, meaning they have to be able to be made modified for individuals with disabilities fairly easily. An accessible route into and through the dwelling is required, and light switches, electrical outlets, thermostats, and other environmental controls must be in accessible locations. And bathroom walls need to be able to be reinforced, are reinforced so that later on grab bars could be installed. And kitchens and bathrooms need to be designed such that a wheelchair could maneuver around them. We've provided whole trainings on the subject of design and construction. So that's all I'll touch on that topic now. Now, lending and brokerage discrimination is also a violation of the Fair Housing Act, and that's why we're here today, right? So if lenders or brokers are involved with the transaction and do any of these things, they are violating of the Fair Housing Act. And that could be in the form of steering or redlining. Steering is the practice of influencing a buyer's choice of communities based upon one of the protected characteristics that I went through earlier: race, color, religion, sex, familial status, disability, or national origin. And steering was really what that testing was about in Long Island. What that testing showed was that individuals didn't even realize they were being sent to one place over another until the testers got the results of the test and said, hey, look what happened to this other person. So that's steering. And it's a really important thing to be aware of in the real estate world. And the other protection here under the Fair Housing Act is that of retaliation. The idea that if you do a protected activity, right, if that you can't take action against someone for filing a complaint, for instance. You can't interfere with their rights under the Fair Housing Act. You can't coerce them, and you can't intimidate them. So everyone has rights under the Fair Housing Act. They get to exercise their enjoyment of their properties, and you can't get in the way of doing that. And if you do that, it is a violation of the Fair Housing Act. Now, there are some exemptions, and they're relatively limited, especially if you're using real estate professionals. For instance, there's a single home exemption, family home exemption, right? But if you're in the business of real estate here, you can't use this exemption, right? So if you own 3 or fewer single family homes, then you can have more say and do things you otherwise couldn't, but not if you use a real estate agent. Likewise, we have the owner occupied 4-unit or fewer exemption, often referred to as the Mrs. Murphy exemption. Here, if you own less than 4 single family homes or condos, then you can have an exemption, but not if you're in the business of real estate. So once you're in the business of real estate, these options go away. So you really can't you are covered by the Fair Housing Act, and you have to comply with the Fair Housing Act at all times. So a few other exemptions. There's a religious organization exemption. You can see on your screen what the requirements of that exemption are. It does not come up very often. I've seen it only a handful of times. So if you think it might be applicable, it's worth researching, but probably not worth too much attention today. The private club exemption, the same thing. It's extremely rare that these are relevant, but know that they do exist if there's a private club involved with the housing. This does come up, this one, senior housing exemption. So this involves the protected class of familial status, because there is housing that under a law called HOPA, the Housing for Older Persons Act, housing can be, in certain circumstances, set aside for individuals over age 55 or 62. And if you do what you need to do to establish housing as housing for older persons, then you have an exemption from discrimination on the basis of familial status. But just the basis of familial status. You can't use this as a basis to discriminate on any other protected classes, be it race or national origin or what have you. And there's 3 ways that you get a senior housing exemption and thereby are able to exclude children from your housing. One is if it's a state or federal program that is designed for seniors. So this one comes up occasionally. We see it at HUD a lot because we operate a lot of these programs at other parts of HUD. But probably less common in your work. But what you probably will come across a lot is 62 and over housing. But if housing is 62 and over, everyone there, all the residents, have to be over 62. You can't make exemptions. And if you do, then the exemption goes away, right? So if you allow someone who's 45 to live there, then suddenly you don't get the exemption and you don't count as housing for 62 and over. So it's very important that if you are claiming these exemptions, that you are very careful to meet the requirements of them. With 55 and older, it's similar, except here only 80% of the units have to have one person over 55. So there can be people younger, but you have to have policies and procedures in place to demonstrate the intent to be 55 and older housing and really maintain it. Because if someone files a complaint saying they were discriminated against, we're going to be looking to make sure that that properties properly established their exemption. All right, so let's take a look at what's happening around New England recently, right? So in Region 1, the office I'm responsible for is covering all of the New England states. And we have issues going on in all of the New England states. So here are a few that I think will be really interesting for you here today. Here's a case out of Manchester, Maine, right? So this came to our attention through one of our partner FIP agencies. Those are the nonprofit organizations that we fund through grants to do fair housing work. This time, Pine Tree Legal Assistance filed a complaint alleging that Page Realty LLC and Ramona Venskus discriminated based on familial status when they refused to negotiate with fair housing testers posing as families with children. They posted discriminatory advertisements indicating that children were not allowed and made discriminatory statements to fair housing testers. We were able to resolve this matter through a consent order, and it cost the Page Realty and Ramona Vaneskis $18,000. In addition, they had to attend training. So that's just one example in Maine, and just really indicative of what sorts of issues we're seeing throughout the country. So let's go to Rhode Island, your state. And on February 11, 2021, our region charged a large landlord in Rhode Island, D&D Realty Management, with discriminating against families with children in their rental properties. This case was brought to us by another one of our Fair Housing Initiative program partners, this time South Coast Fair Housing. They ran a series of tests on the respondent, and that testing revealed that respondent would not rent to applicants with children. And each time a tester informed respondents, and by respondents, we're talking about the people that were alleged to have discriminated against, that they had a child, the viewing would be canceled and communication would stop. Additionally, respondents made statements to testers with children that children were not allowed in the units and that respondent could not accept children. The testing evidence showed that testers without children were shown the same unit and offered the opportunity to rent with respondent. So they were treated differently. Respondent was able to show that they did rent to one family with a child, but that was only done after they were on notice of the complaint being filed. Just last month, on March 15th, the parties entered into a settlement agreement in which the respondents agreed to affirmatively advertise to families with minor children. Respondents agreed to remove language from their website stating that guarantors are required for all applicants, and to change their policy to limit guarantors based on an income threshold. Respondents agree to notify off-campus housing and student living offices at 3 colleges in the area that students with children are welcome at its properties. Respondents have also agreed to ensure that within 6 months, all employees will receive fair housing training at the respondent's cost. Respondents will also notify South Coast Fair Housing within 30 days of receiving any complaints regarding housing discrimination. Respondents in this case are paying $10,000 in compensation to those that were harmed by the discrimination. Let's go to Massachusetts. In this case, brought by another one of our fair housing partners, this time the Massachusetts Fair Housing Center, it also involved testing. Here, a large complex based on this case was based on testing and advertising by agents marketing as a student property. So student property, but it wasn't affiliated with any university. Testing showed that agents were steering people with children away from the property, suggesting other properties in nearby towns that they felt were more family friendly, and only scheduling tours with persons without children for the subject property. Now, this case was also settled, and settlements are very common. The majority of our cases settle before we make a finding, because when the evidence starts to come out, it makes sense and it's in everyone's best interest to do that. So we really try to make that happen where possible, but it's not always possible. But here, the respondents, that the housing complex, agreed to pay the complainant, our Fair Housing Initiatives Program agency, $12,500. They also agreed to affirmatively advertise to families with minor children. They're going to alert our partner when they have available units for 1 year, and they're going to get fair housing training. Now, the complainants reserve the right to test the complex, and respondents will alert the U.S. Attorney if they receive any housing discrimination complaints. So this is just a sampling of some recent cases. They happen to be familial status cases, but we have cases of all the protected classes in our office. And, while these are indicative of some issues, I think you know that it's beyond familial status, that really all the protected classes have results that are like this. And it doesn't pay to discriminate, because these are really, it's expensive. And these settlements can be quite large. And, I hope you understand how we really are looking at these issues everywhere in New England and Rhode Island as well. So I think right now it makes sense to go through some questions that I think you all might have. These questions that I'm going to go through right now are ones that we were given a heads up to, right? That we thought there was enough interest in these topics that they thought we should go over them. So I'm going to go over them. I think once I go over these, we'll have some time to take your questions. So if you type them in, we'll get to those after these initial questions. So the first question that we received was, can real estate licensees or property owners require a potential tenant or buyer to provide proof of vaccine in order to tour or rent a property? So this is a question, obviously, that's related to the COVID pandemic. And the way to look at this question is, well, is vaccination status a protected class? The answer is no. You know, race, color, religion, sex, familial status, and disability are protected classes. Vaccination status is not. However, if you exclude folks that are not vaccinated for COVID, you may be acting in a way that has the effect of excluding folks on disabilities that may not be able to get the vaccine because of their disability. Is excluding people discriminatory? Not necessarily. Could it be? Potentially. And I think that's an important way to look at things. It's not always that clear cut. But if you do things like this and make decisions based on certain characteristics, even if they're not protected, it could have the effect of discriminating based on a different protected class. Next question, and this one, people seem to really have a lot of interest in. And the question is, are buyer love letters prohibited by fair housing laws? And so what my understanding is what they're referring to with love letters are like, you put an offer on a house and you have the person who wants to buy it send a little note to the current owner saying, hey, you know, we really like this property because whatever the reason is. And, you know, they're not explicitly illegal, but they do have the tendency to enable discriminatory housing selection based on whatever's in there. So we are always best off acting in a way which makes it less likely for our actions to be perceived as discriminatory. So here, is there a prohibition on it? No, but could it have an effect? Perhaps. So I know that sounds like a gray area because it is a gray area, but the best way to avoid ending up in a situation where you're being alleged to have discriminated is to try to steer clear of gray areas. The next question. Can a landlord require a tenant to sign a hold harmless agreement not to sue the landlord for issues relating to lead or other risks that the property may pose for young children? And I alluded to we get to this question earlier in the presentation. And here's really the key takeaway on children. And while this question, you know, references lead, here's what you need to understand about this. Any practice that is used on children like this must also be used on adults. The issue is lead is harmful, period, right? If we're talking about damage to often we see damage to property as the issue, right? Kids are more likely to damage the property. So can we charge fees based on that? Well, if you do that, you got to do it for adults too, because adults also damage property. Likewise, so basically anything that you're doing can't be limited towards children, right? So you're not going to hold kids only harmless. You're going to hold anyone harmless. And if you do anyone harmless, you hold everyone harmless, I should say, then you're avoiding treating people different based on familial status. There's no reason why, you know, the kids need this and the adults don't. Even if kids are statistically more likely to cause the damage, why wouldn't you, as a property owner, want everyone who causes harm to the unit, right? Or is concerned about harm, be subject to the same conditions. There's no reason to treat them differently. Yes, lead affects children, but having the lead is something that affects everyone. So you really just want to make sure any policies or procedures you have are geared toward everyone and not based on age, right? So that's really the important takeaway. The next question. When can a landlord refuse to rent to families with children? So I put this here at the end, and I'll just say and cite back to what we talked about a little earlier. There's really 3 different ways that you get an exemption for familial status, families with children, right? And that is if it's a state or federal program, it's housing for those 62 or older, where everyone is 62 or older, or it's intended and operated for occupancy by persons 55 years and older, and at least 80% of the units have someone 55 and older. These rules, especially with the 55 and older, get a little technical, but the point is, if you don't meet these requirements and you're not careful about them, you don't get an exemption for familial status. So, next question. What happens if the tenant support animal is a pit bull or other type of animal that excluded from the owner's insurance policy? Well, insurance companies are subject to the Fair Housing Act. And just as an owner is required to make a reasonable accommodation, insurance companies are as well. So basically, if you end up in this circumstance, you should be asking the insurance company for the accommodation and then let us know if that doesn't happen, because there can be cases against the insurance company for discriminating based on disability. So that, we can provide more guidance. You can contact our office on this if this issue comes up, but insurance companies are very much covered by the Fair Housing Act. So if there's an individual with a disability, they have to accommodate. All right, so another disability related question. Can a landlord require a pet deposit for an emotional support animal? Well, emotional support animals are not pets. Therefore, pet deposits are not applicable, right? So you can have pet deposits, and pets are great properties. People love having pets, but when you have an emotional support animal, you don't have a pet. And I think you have to think about it that way. So would a pet deposit be applicable to something that's not a pet? The answer is no. And emotional support animals are not pets under the law. So the answer is clear. You can't make a deposit for someone who needs an accommodation. And while you can do so for a pet, you can't do it in this case. What type of documentation can a property owner require a tenant with a service animal versus an emotional support animal to provide? All right. So when it comes to accommodations, and what we're looking at here is a reasonable accommodation, we want to make sure, and you can get the information you need to establish a nexus between the need for the animal and the disability, and only enough to establish that connection. So whether it's a service animal or an emotional support animal, a service animal, for instance, if it's a guide dog for an individual who's blind, you might not need very much documentation. It might be readily apparent that the individual needing that animal is blind and that the animal is clearly connected. So you wouldn't really need more information. But if it's an emotional support animal or a service animal where it's not as obvious, you're able to establish just what you need to, so that you know that there is a disability and that there is a nexus between that disability and the animal. Now, is someone disabled is a question that you can look into, but you're not entitled to knowing the disability. Just knowing that the disability exists and has a connection to the requested accommodation, in this case, an animal. So that's an important distinction. You don't need to know the medical records and medical history of someone making a request. You only need to know that there is a disability which necessitates an accommodation. Next question. What steps should a real estate licensee do after discovering that his or her client intends to discriminate? I would recommend that you inform them of their legal obligations under the Fair Housing Act, the Rhode Island law, and any other applicable laws. And whatever you do not assist them in discriminating. If you are in a circumstance like that, I recommend you contact our office. On a slide, a couple more from here, I'll have that information for you. I suggest you write it down and you let us know if that happens. But whatever you do not assist them in discriminating, because then you are, in effect, putting yourself in a place where you are discriminating. So The last question I have for now is what happens when a discrimination complaint is filed? So if someone contacts us, we send it to our intake staff who find out basically what is the allegation? Do we have enough information to take this complaint? Is it timely? So we have some conversations, and assuming all of it is jurisdictional, that is something that we can investigate under the Fair Housing Act, a complaint is filed and our office investigates that complaint. So we're going to look at documents. We're going to talk to people. We might survey a property, whatever it is that we need to do in order to create a record that shows whether or not discrimination has occurred, right? That's what we're looking at. And so we do a whole investigation. And while we're doing that investigation, we're also looking to resolve the matter, because ultimately, if we can get the parties to come together to resolve it early, it's in everyone's interest. But so we continue that process of trying to resolve it while we're doing our investigation. And if it doesn't resolve, eventually we're going to make findings. And if we find that there's reasonable cause that discrimination occurred, we're going to send it over to our legal office, who then issues a charge. And then it can either go to an administrative hearing or to federal court. And it just proceeds down that process. Now, most folks, when they learn or think that they could be subject to a case that is United States versus them, they're very likely to resolve the matter. So, we often do find resolution both before we make a finding and after. But we do bring some cases to court, and that is the process. So there's a lot I could spend an hour talking about how this process works, but know that we do investigate these cases. Know that the Rhode Island Commission also investigates these cases. We work closely with them. We often, if a case comes to us, we'll refer it, or are obligated actually to refer it to the Rhode Island Commission. And when Rhode Island gets a case, they do what's called dual filing. They send it to us, and we put our federal jurisdiction on it, so that a finding by their office really covers our law as well. That's the way the program is set up under the Fair Housing Assistance Program. So we're going to be involved, even if it's just indirectly, if you go to the Rhode Island Commission. But either way, there's going to be an investigation, and we're going to look at those items. So the contact information. Here's how you file a complaint. If you have questions, there's a phone number. You can file a complaint at complaints01@hud.gov. Information and more contact information is at hud.gov/fairhousing. And at this point, I think I'm going to open this up to questions that you watching this today have, and we'll go from there. And just, you might want to write down this information because you could find it helpful.
Jeffrey, thank you. Let me just jump in here for a quick sec. I really appreciate your enthusiasm for your subject and also your willingness to give us guidance. So we do have, you've covered the questions that we sent you in advance. We do have some in the Q&A for you. So we'll get to those in just one sec. I just want to remind everybody that this is being recorded. And if you scroll down to the Q&A on your screen, you will find the link for where this will be posted. Let's say early next week, so our marketing communications department doesn't kill me for saying that. Anyway, okay, so Jeffrey, I hope you have a chance to grab some water or something, and we can start with our questions here. Okay, you good? So we've got a list of them. So one of the questions that we have here is, I'm just going to summarize this a little bit, but if a property, so during COVID, a lot of our members have been doing back-to-back appointments rather than open houses where people can just kind of show up as they please. So if someone holds an open house requiring appointments and a member of a protected class sees the information about the property and shows up without an appointment and are told that they can't see the house because they don't have an appointment, could the real estate agent be accused of discrimination?
So let me break down that question. The answer to the question, could a real estate agent be accused of discrimination? You can be accused of discrimination. Doesn't mean you've discriminated, right? So a lot of cases come to our office, and not all of them are actually, in a lot of them, there isn't sufficient evidence to show that discrimination occurred, right? And those cases are often investigated and closed as no reasonable cause. Nothing's going to stop someone from bringing a complaint if they believe they've been discriminated. And often someone who's been discriminated against doesn't always know. We listened to the Long Island study excerpt, and the individual tester that we heard from didn't really know that she was discriminated against until the testing results showed it, right? So you could always file. Now, the best way to avoid having an investigation show discrimination is to treat everyone the same, right? So if you're requiring appointments and someone shows up and your policy is to tell them to come back and make an appointment, or make an appointment then come back, then do that with everyone. And if you do that with everyone, you keep records of what you're doing, it really shouldn't show as a discriminatory practice, because it shouldn't, it's likely that there is diversity among the individuals who are showing up without appointments. And we're going to look at that information, and we do an investigation if someone filed it. But the best defense to that is, well, we just told everyone they had to come back because that's just the way we're doing things now in this pandemic, and that's okay. So you can't avoid complaint. People will file complaints if they believe they've been discriminated against. You just have to do what you can to have policies that you use universally and treat people fairly.
Excellent. So if everyone listening, the two takeaways I would say, based on what Jeffrey just said, consistent policies and good record keeping. You'll make all your lawyers happy too. Yeah, you'll make all your lawyers happy too. Okay, ready for the next question. If a real estate agent owns and rents an owner-occupied property, does he or she lose the owner-occupied exemption under fair housing law?
That is a very, and one I want to do a little bit more research on before answering here. So I believe the answer is yes, but I am not, I think the answer is yes, but I want to do more research before I give you a final answer on that. It hasn't come up very often. I've heard of it maybe coming up once. So I don't want to mislead you, but feel free to reach out after this presentation and I can get you an answer on that question. But it is very technical. It isn't a very frequent thing. So I don't want to mislead anyone.
Sure, excellent. And I think in general, I know under our state law, which Jeffrey's focusing on federal law, under the state law, I would actually give the same answer he just did about the federal law. But let's just say, as far as advertising and things like that go, the state law holds you to a higher standard than they would to just regular landlords and members of the public. So even if a landlord might be able to get away with some discriminatory advertising, that'll be a little bit different for you.
Yeah,
okay.
and actually, that raises an important point that I haven't raised in this presentation, and there's lots of nuances in the law, but a lot of the exemptions don't. The 804C is the part of the Fair Housing Act which applies to advertising and statements. And the exemptions that I briefly went over earlier, they don't really apply to that. So even if you can legally discriminate, you can't say the reason that you're doing it sometimes. So there really aren't exemptions for the statements.
Okay, good. That's helpful. Thank you. And this one it's more of a question about our new state law, but I'll toss it out there. And if you'd like to answer it, great. If not, I can take it. So the question is, are all landlords required to accept Section 8 vouchers? I thought that was an option.
So the state recently amended their law, which is equivalent to the federal law in many ways, but they added a new protected class that we don't have under federal law, which is source of income. So what that basically means is that if someone gets income from a certain place, you can't discriminate against them. And one way that commonly comes up is individuals with housing choice vouchers, or otherwise known as Section 8. And under source of income rules, if someone has it, you generally have to accept the voucher. Now, not all properties are going to be seeing individuals with vouchers applying based on if it's a high income, expensive property, individuals with vouchers are probably not going to be showing up very often. But at the same time, the law does say that you can't discriminate based on source of income. And if someone shows up and they meet the requirements, and the property is eligible for the program, then yeah, you can't choose someone because they have I should say, they can't not choose someone because they have a voucher. They have to choose based on non-discriminatory reasons. And source of income in the state of Rhode Island is now a discriminatory reason.
Great, thank you. And by the way, everyone who's listening, I've got 10 o'clock right now. Jeffrey, I'm wondering, would you be able to hang out for a couple more minutes? We've got a few more questions in the Q&A.
Absolutely.
Oh, wonderful, good. We're kind of in a roll. So if you have to leave, you can certainly, we'll understand, and you can certainly check out the recording if you want to see answers to any of the questions that you might have missed. And before I go on to the next question for you, I just want to make a quick announcement to folks in the audience. Just to say that I did post in the Q&A a link to more information about the new Rhode Island law that Jeffrey had mentioned. It actually went into effect on April 15th. So lawful source of income is now a protected class. What that means is MLS has already been asking, you can't put something like no Section 8 or no voucher if you've got a listing in MLS. Same thing with your advertising. So if you'd like more guidance about that, you can either take a look at the link that I've posted in the Q&A, or you can just go to rirealtors.org, rirealtors.org, and you'll see more information there with some questions and answers. So let's go back to our guest, Jeffrey, and his knowledge of federal law. I'm going to take one of the questions out of order, if that's okay, because you've just given us some really helpful information about emotional support animals versus support animals. So this question is, says emotional support animals are different from service animals. Anyone can go online and register their pet as an emotional support animal. I know people who have registered their pets as emotional support animals and the animal has no training. How do we avoid the liability side of untrained emotional support animals with an online registration? And I'm going to just add something to that, if you don't mind, just give you a sec here, Jeffrey. I know that HUD had issued a bulletin last year that said that landlords didn't necessarily have to accept internet verification from someone who's never seen or treated the patient before. So I wonder if that might be something you could mention and then comment on the question as well.
You are correct. There was guidance that went out last year on this topic. So I encourage you to take a look at that because it's going to have far more detail than I'm going to state right now. But here's what it really comes down to. I think some of these things, when we get into these nuance, start to get complicated in ways they don't get complicated, because the bottom line is, regardless of the animal or what type of animal it is, the Fair Housing Act doesn't really distinguish between a support animal and a service animal and an emotional support animal. It just talks about reasonable accommodations for individuals with disabilities. And what that means is you have to establish that the individual who needs the accommodation has a qualified disability, right? Meets the definition of disabled, and that the accommodation that they're seeking, there's a nexus between that accommodation and the disability. You have the right to establish that. So if it's an animal of some sort that they need as an accommodation, whether it's a service animal or emotional support animal, there still has to be a nexus between the disability and the need for that animal. And it's going to be different analyses each time you do it, right? But it really comes down to that connection, and that guidance really just walks through that. Just because someone goes online and pays for a certification doesn't mean that that animal is needed for that disability. It might be evidence of it, but it might not be sufficient evidence. You have to establish the disability, and you have to establish a connection between that disability and the accommodation that's requested. An online certification doesn't do that. It's evidence. Is it helpful? Perhaps, but you have a right to establish the disability and the nexus between the disability and the requested animal.
And then also the concern of the person who posted the question was if an animal might be destructive. I think you covered a little bit of this under insurance, but if an animal poses a threat to other tenants or something like that, can the landlord refuse
Yeah, thank you for reminding me of that part of the question. So yeah, here's the thing. Damage to a unit obviously is not, it's something you want to protect yourself from, right? As a property owner, property manager, you want to make sure that the residents of a unit are not damaging the unit. If the animal is in the unit and it causes damage, I understand the need or the instinct to feel like you need a special document to address that. But a document that addresses, a hold harmless agreement that addresses damage to the unit caused by everything, right? That's in, caused by all sorts of things, that is general, would be a way to go, which isn't going to create a specific obligation only on those that have animals as accommodation, right? Your concern essentially is damage to the unit. And if you focus on the concern, the damage to the unit, it doesn't matter. I doubt you really care if the damage was caused by an animal or caused by a person. What you care about is that you have recourse for the damage. So draft documents such that it's not really, that they're used widely, that they're not treating people with disabilities different, and that it's okay to hold residents and occupants and guests into units. You can't hold guests, I guess, but hold the occupant of the unit responsible for any damage that occurs to the unit through the use of that unit. And as long as you do that universally, it shouldn't really matter if there's an animal. It's really just about that universal approach to harm to a unit.
Great, thank you. I know, like you said, you get a lot of questions about disabilities, and these are all really common ones we get about emotional support animals. Okay, so we've got 2 more questions here, and then why don't I conclude with these 2 questions just so we don't keep you or the audience too much longer than planned. So this is also a follow-up to that one is, what if the animal, besides potentially causing damage, what if the animal poses a threat to other people?
It's so there is a doctrine under the Fair Housing Act on direct threat. And basically, if an animal, or in this case, an animal, if something is causing that you need as an accommodation, it's not always an animal, but for our purposes now, let's say an animal that's requested as an accommodation is a direct threat, then the property owner can say, well, we can't have this animal here. But it's a case-by-case sort of thing. Just because it's a pit bull doesn't mean it's a direct threat, right? The animal has to have a history, or there has to be some documentation explaining why this animal is a direct threat. So there is, in these circumstances, really the issue is, does this animal constitute a direct threat to people or property? And it could be either people or property, but there has to be a real record of that. You can't just assume because of the nature of the animal that they cause a direct threat. And just one other note on direct threat, we've seen direct threat in other contexts too. One place where we've seen it is people want reasonable accommodations not to wear masks during the pandemic, and or in common areas, and other folks suggest there's direct threat. So sometimes direct threat can be complicated. We've seen it on reasonable accommodations to smoke, where individuals with asthma and other things might consider, there might be some concern about direct threat there too. It comes up sometimes. It's a case-by-case analysis. It's very detail-oriented, and it looks at the specific case, not like general assumptions about things like, is a pit bull a dangerous animal?
Thank you so much about that. We've got one final question about families with children, and I'm going to just sneak in one just before that. You've been kind enough to give us contact information if people have questions. I know I've heard sometimes from some of our members, maybe no one here today, but sometimes people think, well, if I call the federal government or I call the state, am I going to end up in some file? Like, am I going to get in trouble just by calling? And I think the whole purpose of your presentation is to show, hey, we're happy to give guidance. But could you just quickly comment on that? What would happen if someone had called you up with one of the questions that you're answering today?
Yeah, so we're going to do our best to answer those questions. And I apologize if an echo has showed up all of a sudden. We're going to try and answer those questions. We have to be careful when we answer questions like this because individuals could file a complaint, and we don't want to pre-assume results based on the limited information we receive from someone who calls. So what we would do in answering a question like this, if it's about can we have hold financial responsibility to individuals who have a support animal, we're going to walk through what the law says and try and explain that to you so that you can apply it to your facts. We're not going to go and apply the facts for you. One, we're not allowed to provide legal advice. And two, any advice that we did provide could cause problems should a complaint be filed that we need to investigate. So we'll certainly walk you through the law and make sure you understand and answer your questions, but we can't be fact specific because we have various concerns and problems we can get into if we do that. But we are there to help, and we do get these questions all the time. And, you know, it's our position, you know, we all realize that like, it's much better if you ask questions before you do something wrong than after. So we'd rather be out there providing the education outreach like we're doing today so that you understand these issues so that we prevent these problems, because it's much better for everyone if the discrimination never happens in the first place. Or even where it's not discrimination and it's a close call, we would rather work with you so that you understand the laws and prevent those gray area sorts of decisions.
Well, I hope that that has convinced you to call Jeffrey, because as I said, or people in his department, because like I said at the beginning, they don't bite. They're nice people. They're here to help and here to help you resolve your issues. Just like calling me at the legal hotline. You know, I can't tell you you're 100% right. I can just explain what the law is and what the risks are. Okay, so enough about me. Let's get to our final question. And this is this may trigger some state issues, but let me ask it to you anyway and see if you'd like to comment, Jeffrey.
Okay.
Okay, so this is about renting to families with children. Oh, I'm hearing the echo now too. Okay, so the question is, isn't there something about square footage requirements? So if a family has 5 children and the apartment is 800 square feet with a 2-bedroom, can the applicant be refused? So let me just rephrase that. So basically, is there ever a legal time under federal law where someone can say, this is too many people for this unit without getting into trouble?
The short are occasions where occupancy limits are permissible. However, the law in this area is fairly complicated. There's a bunch of factors in something that's known as the Keating memo that we look at. It's published in the CFR that sets forth when these things are okay and when they're not. So this is the sort of question that is best answered and best looked at on a case-by-case basis because it is fact-specific, these factors in this memo. There are circumstances where it is okay, but there are plenty of circumstances where it is not. And these are some of the cases which require a really in-depth analysis of the law and the regulations. So this is where, technical assistance, talking to your counsel and that sort of action is appropriate because it can be a very hard analysis and certainly, more than I can address right now.
Fair enough. And by the way, any of you who, those of you who are wondering about the state answer to that question, we just actually put out a video that talks about minimum square footage, septic system restrictions, and local ordinances that might restrict the number of unrelated adults who live together, which wouldn't apply to families, but unrelated adults. So keep an eye on that. That's our commercial. And Jeffrey, we can't thank you enough for your presentation today. Susan gave her apologies. She had to leave. With someone with her title, she's got all kinds of breaking things happening all the time. So she had to leave at 9:30. But we really appreciate your time. I do hope that all of you will, let others know who didn't attend this today. Consider sharing the recording with them or urging them to watch it. I think there's a lot of really good information packed in a short period of time. And Agata, thank you as our chair of diversity and inclusion. Thank you so much for being here and lending your support to the program. You're really doing a lot of good things with the committee, and hopefully we can all work together, whether it's HUD or the Realtor Association or the committee, and just kind of stamp out fair housing violations. So On that note, I will bid everyone farewell and thank you again for joining us today. Have a good
Thanks for
day.
having me.
Thank you.
Bye.